Okay, Mr. Thompson, do you have Miss Dango present?
She is here, Your Honor. She asked for a few more minutes to confer with me. We wanted to make sure we were here with the court here. If I could have a few more minutes, I'd appreciate it. Thank you.
We're
Off to a fine start.
sure what the whole point of that was.
Judge Burmeister requires them to be in the courtroom.
we're on the record doing people versus Michelle Dango, file number 255398. Council table. Your appearance.
Sierra Cook on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of the defendant, Michelle Dango.
Mr. Thompson, how did we want to proceed on this file today?
Your Honor, we've had some recent plea discussions. I formally received a plea offer that prosecutor and I have been discussing for some time. I think Ms. Danko is requesting the court set a final status conference and plea cutoff 30 days from now.
Okay, Ms. Danko, what's the reason for that?
Your Honor, I will say we were discussing plea negotiations that involved Ms. Danko. Doing some things to help her own cause that haven't occurred yet, but that she would intend to have occurred.
I just want to know what's going to change between now and 30 days. That's all.
I think there's a possibility the plea could even improve some more.
So, is that correct?
I don't know. This case has been going on way too long, Your Honor. I guess I won't object if the court wants to adjourn it out a couple of weeks, but after that, the plea offer is pulled and I'm not going to continue going down this road with her. We'll set it for trial at that point.
As of 421, the plea offer was an attempt to count one in the withdrawal.
And that's still the offer.
And that's the offer. That is the offer I referred to receiving recently. I guess we did put it on the record on 421. As I said, we had been discussing it for some time, so I don't want to represent that it's exceptionally new. But.
Yeah. So I mean, so we adjourned this on April 21st.
Correct.
We did, Your Honor.
Okay. So Ms. Danko, I mean, that was almost 2 months ago. We're going to enter a plea. It needs to happen today. So if you want to talk to Mr. Thompson a little bit more, but I'm not going to keep delaying this for really no reason. So, and you don't have to accept the plea agreement. That's up to you. I'm not trying to tell you you have to do that, but what I'm saying is you have to make a decision today. You have plenty of time to consider this. You know what the plea offer was on April 21st. It hasn't changed. It doesn't sound like it's going to change over the next 30 days. That's 6 weeks.
I was told it will change.
Doesn't sound like it. You know what it is. You've known what it's been for 6 weeks at least. I'll give you more time here this morning if you want to talk to Mr. Thompson. If we don't go forward with the plea today, the court's going to set it for trial, and I will not accept any pleas after today. One more time to talk to Mr. Thompson. What do you want to do? So we'll set this matter for a jury trial. And Mr. Thompson, I mean, since we're having this discussion, I just want to make sure the record is absolutely clear. Morning of trial, night before trial, week before trial, the court will not accept any pleas after today. So this is the final decision. What the reason is after courts. A lot of times the court is a little more liberal in accepting things late, but because we're having this conversation today, I will not be. Ms. Coke, how much time do you need to be ready for trial in this case?
Your Honor, we can be prepared in 30 days. I'm not sure that we can get it done in one day. Usually I'm able to try one day, but these are pretty significant charges. It's a habitual third. And there's going to be a lot of technical testimony. I think I could do it in one day, but if the defense has witnesses, then we should set it for 2.
This seems like a 2-day trial to me, Your Honor. It's very fact intensive. This isn't like a possession case.
Mr. Thompson, how much time do you want before the court sets this for trial?
I would ask for 60 days, Your Honor.
Ms. Coke, are you anticipating any pretrial motions?
No, I don't think so. I mean, defendant confessed to the case. I don't see any reason to do any pretrial motions.
Mr. Thompson, are you anticipating any pretrial motions?
Not this time, no.
So the court is not going to set a final status conference or we cut off. Since I'm treating today as that. I will set the motion cutoff though 30 days prior to the trial date. So to the extent that parties do have any motions filed, that would be the final.
That's the final date, Your Honor, just so I'm clear.
Filed and heard later.
Oh, yeah.
30 days from there. And I'll send out a scheduling order. Ms. Koch, anything else that we need to address in this case today?
No.
Your Honor, my client's asking if I could confer with Your Honor and the prosecutor off the record briefly. Sure. Thank you.
I'm gonna take, we have a 9:30, so I'm gonna take that 9:30 hearing.
Certainly, Your Honor.
Do you know if Ms. Sheldon is here? Is that the district court?
Yes, she's right here.
Okay.
There's the prosecutor on this case here as well.
Okay.
On the record.
And people versus Andrea Sheldon. Sheldon, right up to the podium, please. Thank you. This is district court case number 2517994. I'm presiding over this file by assignment. If I can have counsel with your parents on, please.
Wilson Broad, Special Prosecutor, Your Honor.
Thank you, Your Honor. Jason Thompson, attorney for Andrea Duncan Sheldon.
This is set for a status conference today. Mr. Thompson, tell me where this file is at.
Yes, Your Honor. There's a plea offer in this matter to plead to a deferral. Discussed that with Ms. Sheldon. She's indicating she wishes to reject that offer, exercise her right to a trial. She didn't want the court to address her bond conditions. There is a bond condition prohibiting contact with the alleged victim in this case. In this case, the alleged events happened February 7th, 2025 for reasons. Nothing was charged until late April. In the meantime, the parties have been residing together. There haven't been any problems. They both made their statements to law enforcement. I don't believe there's any public safety or administration of justice concerns that would justify displacing her from the home, separating the parents of the minor child they share together. They do have a statement from the alleged victim asking that no contact was dropped as well.
Got a chance to see that, Mr. President?
It's just handed to me, Your Honor, so no, I haven't, but I'll read it. The court will give me a moment.
Sure. Just a second.
I don't believe that gentleman, Mr. Josh Sheldon, is here today, but stopped by my office yesterday and dropped that off. And Your Honor, in terms of the allegations in this case or the offer of proof, I mean, they're very minimal. There's an allegation that Ms. Dunkley sprayed some sort of cleaning product in the direction of her former husband while they were having an argument about cleaning things.
Mr. Brad?
Well, I think the allegation is that Ms. Sheldon sprayed OxyClean in her husband's face and got into his eyes, and his eyes were burning, according to him at the time. At the time, I think the defendant denied that, but regardless, I guess with regard to the no contact provision, those are things that I think policy is to leave in place as long as these sorts of cases remain pending, absent some change in circumstance. The delay in charging was basically because a special prosecutor was required, and that takes some time to process through. For no fault of my own, but certainly there's a process for that, and it does take probably too much time, but that is what it is. Regardless, I guess with respect to the no contact, I'll leave it to the court's discretion. This was not violent in the sense of throwing punches or putting hands on people. It was, but nonetheless, it's still an assault. So I'll leave it to the court's discretion.
I do know that Dr. Michelle had approached Grace Center about the family counseling. She would ask the court to consider, that it would be beneficial for both her and the alleged victim to undergo that kind of counseling together. That would necessitate contact. Thank you.
In terms of scheduling the trial, Mr. Pratt, do you have any timeframes that we need to accommodate? As a special prosecutor here, I know there may be some different considerations.
Not that I'm aware of, I guess, as far as I think this is probably most district court matters, I think, like this, we could probably get done in half a day or a day at most. So I don't, and there's, without knowing what dates the court's considering, I don't really have any other input as to that at the moment.
Okay, so as soon as the court get a date scheduled, which likely is going to be probably at least 30 to 60 days.
That should be fine, Your Honor. And if there's an issue with a particular date that gets set, I'll certainly notify the court immediately.
Okay. Mr. Thompson, in terms of being ready for trial in this case.
Yeah, we're ready today, and I would concur. We could probably have this done by 1:30, one-day trial.
Okay, so the court will set up for a one-day jury trial at the court's next available date, so we'll get it on the docket as quickly as we can. With a short trial like this, get it on the docket quickly. So, in terms of the bond conditions, in domestic violence cases in particular, no contact is an important bond condition for a variety of reasons, not necessarily just for the safety of the person who is the alleged victim. Particularly because this case is going to be going to trial, and because Mr. Sheldon is the complaining witness in this case, I don't think it would be appropriate to lift that no contact, because you're going to be adversarial parties in the trial coming up, and have you living under the same roof gives the court concerns for the integrity of testimony at any trial if there is contact between now and then. So for those reasons, and given the nature of the case, the court is not going to modify the bond at this time.
Okay.
But again, understanding that the parties share a child, that do wish to engage in counseling, which of course I think is a good idea, but I think this needs to be resolved before we can move forward with those kind of things. So the court will get it scheduled as quickly as it can. Mr. Brad, anything further that we need to address?
No, Your Honor. Thank you.
Thompson.
Nothing further for today's record, Your Honor.
All right. Did you want this letter back, or did you?
Yeah,
want
that's
it back? Thank you. All right. Thank you. That's all for today.
Thank you, Your Honor.
Fill out anything?
Just the judge.
Thanks. Mr. Thompson, do you know if you're handling Mr. Kinsler's matter? That's Mr.
I was.
Fisher's case. Okay, he's available. Sir Kinsler, are you able to hear me okay?
Yes, sir.
We're on the record now in People versus Jonathan Kinsler, file number 225113. The record should reflect that Mr. Kinsler is appearing by video today by prior approval of the court. If I could have the council put your appearances on.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson on behalf of defendant Jonathan Kinsler.
And Mr. Thompson, you have not been appointed yet.
Correct. This is an arraignment. My understanding is there's an issue with payments. The claimants, they haven't been made.
Got it. So, Mr. Kinsler, you're before the court today on a technical probation violation, and the allegation is that you failed to make any payments towards your court-ordered fines and costs, which is a requirement of your probation. Which is the first violation.
Yes, Your Honor.
So, Mr. Kinsler, the maximum penalty that you could face for this violation would be up to 15 days in jail. You do have the right to have a hearing as to whether or not you did violate your probation as alleged. You also have the right to have an attorney present at any subsequent proceedings. If you can't afford an attorney, one would be appointed for you at public expense. Mr. Thompson is here to represent you today, and to the extent that you need to consult with him, I would certainly give you time to do that today if you needed to. Do you understand all those things that I've stated to you?
Yes, sir, I do.
Okay. Mr. Thompson, did you have a chance to talk to Mr. Kinsler?
I have not yet spoken to Mr. Kinsler.
Did you want to be able to do that?
I had talked to the probation officer, and I believe there was a consideration of perhaps adjourning this out to allow those payments to occur. Okay. I would be agreeable with that before consulting with him.
Okay, Mr. Haven.
Yeah, I would not object to an adjournment. I'm not sure of his employment status. The latest I see, he lives in Oakland County and is supervised there. So last case note, I saw that he had applied for some VA disability. So I don't know if he's currently working. I know he had been. We've extended his probation once already. So if he has any source of income, yeah, I would like to see some payments and maybe adjourn 60 days to see if that can happen.
Okay. Have you been able to talk to Mr. Kinsler?
I haven't talked to him.
Okay. Mr. Kinsler, do you have Mr. Haven's contact information?
So yeah, I believe in the court summons that I got through email, I believe there's contact information in that, but I'm not 100% sure. If you could give me his information today, I can contact him by phone.
Okay, Mr. Haven, can you do that?
Okay, you got something to write with?
Give me 1 second. Okay, I'm ready.
Okay, my phone number is 989
Uh-huh.
344
Okay.
3251.
Okay.
All right, so Mr. Kinsler, what I'm going to do for purposes of today's hearing is I'm going to enter a not guilty plea on your behalf.
Mhm.
I'm going to set this as a PR bond, so you don't have to post any money, but the conditions of that bond will be the conditions of your probation.
Yes, sir.
And then I'm going to set this for a hearing in about 60 days. I'm going to ask you to get in touch with Mr. Haven this afternoon and talk to him about what we can do to resolve this issue, okay?
Yes, sir. Sounds good. I appreciate it.
All right, Mr. Haven, is there anything else we need to address today?
Nothing further, Your Honor.
Mr. Thompson?
Nothing further. Thank you.
Mr. Kinsler, do you have any questions at all?
No, sir.
Okay, thank you. That's all for today, and you're free to disconnect at this
All right.
time.
Thank you, sir. Y'all have a good day.
Thank you. And Mr. Thompson and Ms. Pope, if you want.
Thank you.
I don't know how to disconnect this, and I think they can hear me in the court, so.
We're on the record in People versus Cameron Spencer, file number 255404. The record should reflect that Mr. Spencer is present here in the courtroom today. If I can have counsel put your appearances on.
Sierra Coke on behalf of the people.
Good morning, Your Honor. John Mott on behalf of Mr. Spencer.
Thank you. This is the date and time set for a status conference in this case. Counsel, can you tell me, do we have an agreement? I believe
We do.
Can you tell me the terms of that?
Your Honor, Mr. Spencer will be pleading no contest to counts 5, 7, and 9 in exchange for dismissal of counts 1 through 4, 6, and 8.
And that's been reduced to writing, Your Honor, and signed by all of us. I believe if Mr. Mott has it or if he's already given it to the court.
And what's been stated by counsel is consistent with the agreement as placed in writing. Mr. Spencer, have you had an adequate opportunity to speak with your attorney about this plea agreement?
Yes, Your Honor.
Do you need any more time to do that before we go forward today?
No, sir.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I solemnly swear that the testimony I'm about to give will be the truth, and nothing but the truth, so help me God.
Thank you. Lower your hand. Mr. Spencer, are you currently on any kind of probation or parole?
No, sir.
All right, and you understand, I'm gonna go through the maximum possible penalties for each of these charges that you're pleading no contest to, okay? The first charge that you're pleading no contest to is count 5, which is 2nd-degree arson. That's a felony that carries with it a maximum possible penalty of up to 20 years and or a $20,000 fine or 3 times the value of the property that was damaged or destroyed, whichever is greater. Do you understand that maximum possible penalty?
Yes, Your Honor.
Count 7 is malicious destruction of personal property of between $200 and $1,000. That is a misdemeanor that carries with it a maximum possible penalty of up to 1 year in jail and or a $2,000 fine. You understand that?
Yes, Your Honor.
So the information I have here in the file is 8 count.
It's an added count 9 to home invasion 2nd degree.
What's the maximum possible penalty for that charge?
It is a C-grade felony, 15-year and or $3,000.
Okay, you understand that maximum penalty, Mr. Spencer?
Yes, Your Honor.
And you're on the PAT code for the clerk is 750.110A3.
Thank you. Mr. Mott, are you aware of any potential either mandatory or discretionary consecutive sentencing sanctions?
No.
So, Mr. Spencer, then with all of those maximum possible penalties in mind, what did you plead those charges today?
I believe it's a no contest, Your Honor.
All right. I'm going to go through your rights with you. I know you've done that with your attorney, but I'm going to go through them with you here on the record as well. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at a trial. You have the right to remain silent during a trial and to not have that silence used against you. And the right to testify at a trial yourself if you wanted. You understand that you have all of those rights.
Yes, Your Honor.
Understand you're giving up, waiving all of those rights by pleading no contest, including the right to have a trial.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. You can only appeal it by leave, and that means that you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. You understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead no contest?
No, sir.
Has anyone promised you anything other than what we've said here in court today?
No, sir.
Is it your own free choice to enter this plea?
It is indeed.
Okay, council, it looks like we've got a police report here from Crawford County Sheriff's Department. It's report number 241-200-1371. I'm referring specifically to page 18, 24 of that report. I haven't had a chance to look at it, so I'm just going to read through that.
Take your time.
Okay, Ms. Koch, have you reviewed that police report specifically page 18?
Yes,
And would you agree that that would form a factual basis for finding guilt as to counts 5, 7, and count 9?
yes.
Mr. Matt, have you also reviewed that report?
Yes, and to be clear, Judge, would there be a finding of no contest or we just?
Well, the factual basis has to support a finding of guilt.
I agree that the factual basis.
All right, Ms. Koch, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Counselor, you?
There's none.
Ms. Koch, are the people satisfied that the court has complied with statute for taking it?
Yes, Your Honor.
Satisfied, Your Honor, thank you.
All right, Mr. Spencer, the court finds, I'm sorry. Yeah, Mr. Spencer, I find that that your plea is knowing and voluntary. I've reviewed page 18 of that report. The court finds that the information contained within that report would support a finding that you are guilty of counts 5, 7, and the added count 9. The court will accept your no contest plea. The court will mark and admit that police report as court exhibit 1 for the file for purposes of preserving the factual basis. And we'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. Prior to that, you're going to meet with someone from the probation department. They're going to do a pre-sentence interview and prepare a report. You'll have a chance to review that with your attorney before that sentencing hearing. Ms. Koch, anything further that we need to address today?
No, thank you.
Nothing further, thank you, Your Honor.
Thank you. That's all.
Thank you, Your Honor.
Mr. Thompson?
Yes, of course, available. We ask the court to call the Dango matter, please.
People versus Dango, file number 55398. Just Dango, if you want to come up to the podium, please.
Thank you, Your Honor. We did meet with the court off the record. I think it's a fair summary that the court reiterated its earlier ruling. Ms. Dango has reconsidered her decision and would like to enter a plea at this time to the offer, which is 1 count of attempted aggravated stalking with no habituals. That's a 2.5-year maximum.
Ms. Koch, is that a correct statement of the plea offer?
It is.
Dango, after further discussions with your attorney, is this how you want to proceed today?
Yes.
Raise your right hand, please. You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you for your hand. Are you currently on any kind of probation or parole?
No,
And you understand, as Mr. Thompson stated, that you're pleading to an attempted aggravated stalking. And as an attempt, the maximum possible penalty for that crime is 2.5 years instead of 5 years.
yes,
And in exchange for that, all the other charges and the habitual third offender enhancement would be dismissed. Is that your understanding?
yes,
And with all of that in mind, what is your plea to the attempted stalking?
guilty,
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at a trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf here at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want. You understand that you have all of those rights.
yes,
And you understand that you're going to be giving up and waiving all of those rights by pleading guilty.
yes,
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask for the Court of Appeals to hear your case. They could say no, and then that would be the end of any appeal. Do you understand?
Yes.
Has anyone threatened you with anything to get you to plead guilty?
no,
Has anyone promised you anything other than what we said here in court today?
no,
Is it your own free choice to enter this plea?
yes,
Are you pleading guilty because you are actually guilty of this crime?
yes,
The information I have indicates that this occurred between late December of 2023 and March of 2024. Is that the correct time frame?
yes,
And during that period, Mr. Thompson.
Could I lead the questioning at this point, Your Honor? Thank you.
Thank you.
All right, so Ms. Danko, at that time period the judges referred to, were you in a romantic relationship with a gentleman named Logan Klume?
yes,
All right, and Mr. Klume had an ex-partner named Stephanie Gray, is that correct?
yes,
All right, and did you purchase a Cube GPS tracking device on or about December 27th?
yes,
All right, and was that tracking device used by Logan Klume to track Stephanie Gray?
yes,
All right, and that account was set up in your name? No,
No.
you set it up though?
no.
No.
He said it over his name.
Okay.
I
Go
had
ahead.
access to it at some point,
Sure,
but,
you actually purchased it,
yeah,
the tracker, okay. And you learned by at least February 5th that he was using it to track Miss Gray?
yeah,
All right, he would tell you he was using it to track Miss Gray? And you didn't take any steps to discontinue or stop your involvement in that GPS tracking cube,
correct,
which you had purchased?
correct,
All right. And you agree that Mr. Klume tracking Stephanie Gray was part of a pattern of stalking?
yes,
All right, that he was doing actions that would make Miss Gray feel stalked, threatened, harassed, and intimidated?
yes,
All right. And did those actions happen here in Crawford County?
I believe so,
Yes. Okay, sorry. You believe some of those actions occurred in Crawford County? Some of your actions occurred in Crawford County, correct? Like purchasing the tracking device? All right. Do you agree then that you aided or abetted Mr. Logan Klume in his stalking of Stephanie Gray?
yes,
How many further questions, Your Honor?
Are you satisfied with the factual basis?
Yes, Your Honor.
Ms. Coke, are you aware of any threats, promises, or inducements other than what's been placed on the record?
Your Honor, we'll be forfeiting the GPS tracker, but that's really a sentencing issue, nothing else.
No objection to that provision. It's not spelled out, but it is contemplated by state law as it's an instrument of a crime.
Ms. Coke, are the people satisfied that the court has complied with statute and court rules and statements, please?
Yes,
Yes.
Ms. Danko, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis In support of finding that you are guilty of this charge, the court will accept your guilty plea. This matter for a sentencing hearing, you'll be notified of the date and time of that hearing. You're going to meet briefly today with the probation officer to set up a pre-sentence interview. That is all for today. In light of the plea, the court will not go forward with scheduling this matter for trial. Thank you. That's all for today.
Thank you. Should I go talk to Mr. McFall out in the hallway?
No. Thank you.
All right, Mr. Morris, can you unmute, please?
Of course.
Thank you. You're appearing on Mr. Letson's matter, is that correct?
Yes, thank you.
And on the iPhone, is that you, Mr. Letson?
It is, Your Honor.
Okay, great. All right. We'll go on the record now. This is People versus Devin Letson. This is file number 255389. The record should reflect that Mr. Letson and his counsel are appearing by Zoom by prior approval of the court in this case. And if I can have both counsel put your appearances on the record, please.
Sierra Coke on behalf of the people.
Good morning, I'm Barton Morris, appearing on behalf of the defendants.
All right, this is set for a status conference today. Mr. Morris, can you tell me where things are at from the defense side, please?
Yes, Your Honor. So first I'm standing in for the attorney of record, Tyler Velo, but he is in my office. I was advised that perhaps the prosecutor, Ms. Chadi, had given us a previous offer, and I did email her with respect to a response. And perhaps maybe she's not available, or I don't know if she received it. So I do believe we're closer to a resolution, but I have to finalize the discussions with the people.
So the offer on this case is plea to a domestic violence first degree. I spoke to Mr. Lviv. I'm sorry. I don't know who he's emailing. I think he emailed my assistant prosecutor. But I talked to Tyler yesterday, and I don't know what he decided to do.
Oh, okay. Well, I had was going to request, instead of a DV, was an A and B.
The assault and battery has the same effect as the domestic violence. You can use them on additional domestic violences, which I think is what the concern is. Ms. Shady's messaging me because I think he was messaging the wrong prosecutor. So I don't really see the purpose of doing it as an assault and battery because it's going to have the same long-term effects. But
No,
we can do it that.
Disagree.
The defense office did call me yesterday. I spoke to them. They were confused. They thought that he entered a plea. District court told them no, he's not for a jury. He got his year. This is his first hearing here, and he did not enter in a plea.
All right.
The attorney of record is in a jury trial today or some type of trial today. That's what's happening. I talked to him yesterday.
That is correct.
Yeah. If it's, I normally we don't extend the, I don't know what the confusion was. We don't extend the plea offer, but if the court wants to set this out like just on the next court date, I can talk to him again.
All right, Mr. Morris, is there any objection to that?
Oh, yeah.
All right, because it sounds like this matter is going to resolve by plea, the court will set this for a hearing on my mid-June motion day. So Mr. Morris, if you want to communicate to Mr. Velo and of course to your client that I'm going to set this for a hearing in about 14 days. the court will provide notice of the date and time of that hearing. If your side wants to appear remotely, just make that request to my assistant Jennifer prior to that hearing date. I don't have a problem with that. But the gist of it is that if we're gonna have a plea, it'll need to happen on that date. If there's not a plea, then the court will set it for trial and the court will not accept any pleas to any lesser charges after that next date, okay?
Yes,
So just make sure that you or Mr. Velo talks to Mr. Letson and that he's ready to make a final decision on a plea at that next hearing.
we will.
Mr. Letson, were you able to hear that?
Yes, Your Honor.
Okay. Ms. Koch, anything further we need to address for today?
No, I'll get in touch with Mr. Vilas. Sorry about the confusion with the wrong prosecutor. I'm not sure what happened there.
All right, Mr. Morris, anything further from your side today?
No, Your Honor, but I will update our records to make sure that we have the proper prosecutor, and we will diligently continue to come to a resolution.
Okay. All right, thank you. You and Mr. Letson are free to disconnect at this time.
Thank you.
Your Honor.
Next hearing is at 11:15. We'll be in recess until then. Okay.
Morning, Your Honor.
Good morning. We'll go on the record, People versus Brent Michelle's case number 224992. If I could have counsel put your appearances on, please.
Sierra Coke on behalf of the people.
Attorney Sorin Panainte, P number 85326 on behalf of Mr. Brent Michelle's.
All right, thank you. We're on the record today for a motion to correct sentence. Mr. Michelle's was originally sentenced by the court in this case. That was then subject to a motion for resentencing, which the court granted. That resentencing hearing was held on Thursday, June 6th of 2024. The defendant then filed this motion on two bases, and correct me if I'm wrong, counsel, but one was based on the court's reliance of the victim impact statement, and the other was the court's failure to articulate the sentence on one of the other counts that was not the subject of the motion, and for which Mr. Michelle had already served his time, but the court did not articulate that. Mr. Canante, is that correct statement of your arguments?
That's correct, Your Honor. It's my understanding Mr. Michelle should be connecting shortly from MDOC as well.
Okay, we'll give them a couple minutes to connect here.
We had some we had some issues with the telephone beforehand as well speaking, so that's why there's a slight delay. I apologize.
Okay, no problem.
Not up and down as you need it.
All right. All right, Mr. Michelle, are you able to hear me okay?
Yep.
Okay, great. Okay, so we do have Mr. Michelle's connected now. Mr. Canante, did you want to present any oral argument in support of your motion here today?
Yes, Your Honor. Briefly, if I may.
Please.
First, I should note I have not received a response from the people. I understand that the issues I have raised are relatively limited. One is the reliance on the victim impact statement. The court may consider a victim impact statement, but Mr. Michelle's is entitled to challenge the accuracy of that. His counsel at the resentencing noted no objection to that. So I have to make, frankly, an objection now before we may proceed further up above in this matter. I understand that that might be moot considering that his prior counsel didn't object to it. Additionally, there's a smaller issue, which is the sentence in regards to count 4. Mr. Michelle's wasn't informed of that sentence. When I looked at the judgment of sentence as well, I don't believe I saw it in there originally. I think that's a straightforward correction that could be made today. Otherwise, that's the crux of my argument, Your Honor.
All right, thank you. Ms. Koch, anything that you wanted to add?
Yeah, I think by the time that this got resentenced, they only were addressing one of the counts. So I'm not sure that the court had to readdress it since it had already been sentenced. But he had already completed a sentence on that. So I guess if we want to put that on the record, we can. As to the first issue, I think the court properly relied on the victim impact statement, and I'd ask the court to continue its previous ruling. Thank you.
Mr. Canente, anything in response to the prosecutor's argument?
I agree that the second issue could be addressed today. That would allow us to resolve that matter. In regards to the victim impact statements and the statements contained therein, I would request a hearing to be able to challenge those matters further.
All right, thank you. So I reviewed the motion. I also went through, I reviewed the file. I reviewed the initial or original sentencing hearing and transcript. I reviewed the resentencing transcript, as well as the judgments of sentence that were issued as a result of both. As to the sentencing on count 4, which back in September of 2022, the court sentenced Mr. Michelle's on that count to 206 days in the Crawford County Jail with credit for 206 days served. That sentence was not at issue in the resentencing hearing at all. You know, the court did not reiterate that sentence at the time in June of 2024. Because even as of the original sentencing date, Mr. Michelle had already served that sentence. I do appreciate counsel's thoroughness, however, I'm not sure from a legal standpoint or a procedural standpoint, whether or not the court would have been required to reiterate a sentence that had clearly been served and was not the subject of resentencing. However, again, you know, I do appreciate counsel's desire to be thorough. I don't know that it would form the basis of any type of appeal, but regardless, for the sake of the record, the court will impose that sentence as to count 4, which was the intentional dissemination of sexual material, and impose a sentence of 206 days with credit for 206 days served. To the extent that that is not contained within the amended or new judgment sentence, which it is, 2024, I'm not going to order that a new judgment of sentence be issued because that was in there. I think this was just, I guess, a matter of correcting the record here and allowing Mr. Michelle to hear that. As to the victim impact statement, Mr. Michelle has now had, this is now the 3rd time that he's had an opportunity to object to that. The court, as a matter of pretrial, I guess, as a matter of post-sentencing motions, isn't required, I don't think, to continue to consider issues regarding the original sentencing. I've already considered one motion to resentence. It was not objected to at that time. It wasn't objected to at the original sentencing. I don't think the court is required to continue to give Mr. Michelle's motion after motion after motion on resentencing, just continuing to raise new issues each time. So I'm declining to rule on that issue. I find that any objection to that has now been waived and has been waived since the last motion for resentencing. Although, again, I appreciate counsel the need to raise that to the extent that he wants to try and object to that on appeal, but I find that any objection to that at this point has been waived. So the court's declining to rule on that as part of this motion. Because I don't even think it's properly before this court on this motion for resentencing, let alone later in front of the appellate court. But again, I understand counsel's reason for doing so. So that's the court's ruling. Mr. Penente, if you would prepare an order that we're work today on that issue. I preserved the sentence for the record. Again, I'm not going to order the clerk to generate yet another judgment of sentence. Both previous judgments of sentence accurately address the sentence as to count 4. Mr. Penente, anything else for the record today?
Nothing further, Your Honor, but I would inquire if I could order the transcript on the record or if the court would like me to submit the SCAO form for today's proceeding.
Yeah, but you can submit the form so that we have the paperwork to follow the file.
Understood. And I will prepare that order. And is it Miss Cook?
Yes, you have my permission to sign.
Thank you. I will do so and then submit it for filing to the court. Thank you.
All right, Ms. Koch, anything further from your side?
No, thank you, Your Honor.
All right, thank you. That's all for this hearing today. All parties are free to disconnect at this time.
Thank you, Your Honor. Take care, Brent.
All right, that concludes the court's morning.